All right. Good morning, everyone, and welcome to the internet version of the Kansas Court of Appeals. For oral arguments, we have one case to hear today, and that is the L. Ruth Fawcett Trust et al. Versus Oil Producers, Inc. of Kansas. My name is Mike Boozer. I'll be your presiding judge. I have today joining me as part of our panel, Judge Steve Hill, who you are all familiar with, and Judge Sarah Warner, who you probably also are familiar with. And those two individuals and myself will compose the panel to hear this particular case. We're allotting 20 minutes per side for this case. We have an appeal and a cross appeal. I think it'd just be easier if we take this up all together, both the appeal and the cross appeal, when you address the court. And then Mr. Sharp, if you could tell me how much time you would like in rebuttal, I'll be happy to accommodate you on that.
Your Honor, I would like to have 5 minutes in rebuttal.
All right, so you'll have 15 at the start and then 5 in rebuttal. And you may proceed.
Thank you, Your Honor. On behalf of the class, we have 3 issues: the motion to amend so the class can have their day in court on the newly established law from OPIC 1, the prejudgment interest issue so the class can receive at least some interest on what was not paid to them, and then the third issue is whether the equitable estoppel trial was proven with respect to the deceptive accounting. I'll begin with the first issue on the motion to amend. We believe that the motion to amend should have been granted. It was not granted because the district court believed that the mandate precluded it, that she could not consider the motion to amend because the mandate had already held, in her view, that defendant had won. But I do not see anywhere in the actual mandate itself, which only says that there was a reversal as to the issue subject to their review, does not reverse and render and does not grant judgment against the class.
Mr. Sharp, I have a question for you. In your view, what did the Supreme Court say in their opinion about the claims from the class? Did they not reverse the district court when it ruled that you were entitled to summary judgment on the issue of what or when a sale, a marketable sale of this gas takes place?
That's correct, Your Honor. It did hold that the class could not prevail as a matter of law. Our position was that the interstate pipeline and index would set the valuation point as a matter of law, and the OPIC 1 court held that's a question of fact. And in that particular instance, both parties.
Well,
actually,
no, it said more than that, didn't it? Didn't it say that they, didn't the Justice Miles say explicitly that they have shown this is marketable? And what goes from that is, what's the damage?
Yeah, what I believe the court held was that that the marketable condition issue is now gauged by what is a good faith sale. Both parties admitted that in their view there was no dispute as to fact because both parties accepted the terms of the written midstream contracts. The written midstream contracts, however, under plaintiff's view, had the sale actually occurring at the transmission line, at the interstate pipeline. Under defendant's view, the sale was actually at the gathering line. So the inferences gathered from the undisputed facts left a question of fact for the fact finder to resolve. When the law changed for the first time in OPIC 1 to recognize this good faith sale concept, which was an issue that was not raised in the district court, was not raised in the Court of Appeals in OPIC 1. Interestingly, it was not raised by either side, but was really brought upon us sua sponte in the Kansas Supreme Court. It's our belief that that change of law, we should be allowed to litigate that issue on the change of law so that the class's rights are not prejudiced.
Are you bound by the stipulation that you made when you submitted the matter to the district court for summary judgment, that you were not questioning the good faith or making allegations of bad faith on the part of the oil and gas producers?
I think that was actually a concession that was made during the oral argument as opposed to a factual stipulation. So the question would be, can that concession be withdrawn with respect to the rest of the case? I don't think it's necessary to reach that issue, because even in our request to amend, we still contend that the terms of the agreements are as written. And based on the terms of those agreements as written, the sale was at the transmission line. All of that gas, as the court will probably see from the Cooper Clark versus Oxy case, the Judge Lieben wrote in that case that the issue was, where was the gas intended to be marketed? And in every one of those gas contracts as written, the intended market was the interstate pipeline. It was not the local market.
Counsel, could you articulate the difference between the proposed amended claim that is based on this duty of good faith and fair dealing, and then the previous claim that you had asserted based on the market condition rule?
Sure. Under the amended request, we accepted as written the midstream gas contract, and under the breach of the duty of good faith and fair dealing for marketable condition, addressing the deductions, we argued on the alleged facts is that the midstream gas contract was a good faith sale at the transmission line, so that the gross sale price was the index price, and it was not a net price, which is what OPIC delivered. And we got there based on what's in the gas contract itself. The risk of loss did not pass at the gathering line inlet because of the loss and unaccounted for gas. It did not pass at the gathering line inlet because OPIC was still responsible for the cost of services past the gathering line inlet, namely the gathering, compression, dehydration, treatment, and processing costs.
Counsel, I'm going to stop you right there and just clarify. I thought that I just heard you say that you weren't contesting the good faith of marketing from the transmission line or at the transmission line. So how is this a claim based on a breach of the duty of good faith and fair dealing?
The duty of good faith and fair dealing between the plaintiff and OPIC is a different a different analysis than the good faith between OPIC and the midstream companies. We don't contest, and we accept as written the midstream agreements as being in good faith, but they cannot trade upon the good faith of the royalty owners by allowing this title transfer clause, if that is indeed considered a sale, which we do not believe it was in OPIC 1. OPIC 1 expressly noted that sale of gas can occur lots of different places, but it never once said the transfer of paper title equals a good faith sale. A good faith sale remains a question of fact. So with respect to the good faith and the second issue under the implied duty that we asserted in the amended complaint, that second issue is the mutual benefit rule, which goes hand in hand with the good faith duty. The mutual benefit rule says that OPIC cannot do something that benefits us or benefits it only, but does not benefit the plaintiff. For instance, if it actually uses the title transfer clause in the gas contract in an effort to visit the expenses onto the royalty owners, All that is a benefit to them and not a benefit to the royalty owners who have to bear that burden. Our experts have already opined that it was not necessary to have that kind of a title transfer clause in the gas contract at that particular point. So
That is
regardless,
Oh, I'm sorry.
If I could, it seems to me that if you were in Oklahoma, that would be the rule. Am I correct in that?
I
Doesn't
believe,
the Oklahoma Supreme Court embrace that, but the Kansas Supreme Court has not?
yeah, I would have initially thought that was the case. And I agree that it would certainly be the case in Oklahoma, because the Chaparral case, as the court knows, had a two-step process. The first, what was the intended market? And the second, is that intended market, were there any midstream gathering, compression, dehydration, or treatment or processing services needed to meet that market specifications? That's the Oklahoma test as announced in Chaparral. It's interesting when you compare that test to what the judges Lieben, Gardner, McEnany found in the Cooper Clark versus Oxy case, in which it said, quote, Fawcett establishes a simple principle. When parties define a market for gas through their conduct, that gas is marketable when it is in a condition acceptable for that intended market, unquote. It's almost the exact same issue in Oklahoma and Kansas now, focusing on the good faith sale in a market. The reason for that is,
Counsel, didn't the Cooper Clark case also distinguish Fawcett and in particular Fawcett 1, and said that in this case there was a market because there was a sale, and so that issue wasn't even present here?
yes, in Cooper Clark versus Oxy, the sale without a doubt was after processing. It was at the interstate pipeline. That was the first attempted sale. There was no title transfer clause. The only difference between the gas contracts in that case in Cooper Clark versus Oxy and the gas contracts in OPIC 1 is one single sentence about title transfer. And there's nothing in OPIC 1 that says the title transfer, paper title transfer, can be determined, will determine where the sale and good faith sale location is, because there are so many things that occur within that gas contract that occur after that paper title transfer. As I indicated, risk of loss, cost of services, monetization of the gas does not occur at the gathering line inlet. It occurs at the transportation line, usually in percentage of proceeds contracts, because the proceeds are actually determined at the market at the transportation line. And even the title transfer clause in the written gas contracts is not a completed title transfer, because nothing is actually transferred until you've got all of the subsequent contractual duties completed. So,
Counsel, if I could, I've got to ask you some questions. I don't know where you are in your time, but I want to ask some questions about, this is a class and you certified the class, but if you get into a question of good faith, doesn't that imperil your class certification? Because would not the court have to look at each transaction to see if it was done in good faith when you were doing this? Or am I mistaken on that? Because it seems to me that you've got, what, about 2,200 royalty owners here, and would not the court then have to examine each one of those transactions?
well, the court could certainly take a look at each of those transactions, although they're all going to be written transactions in which, as we've indicated, we're going to accept the written word as it is. So given that the written contracts will speak for themselves, there will be no evidence from royalty owners, and certainly no evidence from royalty owners in which their testimony would vary. Simply put, they have no knowledge whatsoever about any of these gas contracts, because they're all secret and confidential. So it won't impact the class certification one way or the other. The only issue will be, what do those written contracts show? do they show that the gas is in marketable condition by a good faith sale at the transmission line or at the gathering line? And that'll be a factual dispute. I expect experts will testify.
It seems to me that that factual dispute that you want to seek expert testimony on is at the heart of Justice Biles' ruling when he said, hey, this was marketed.
Yes.
And so that question's closed.
No, it's a difference between marketed and sale. In his opinion, the issue is not when gas is marketed, because I can say pretty point blank that all gas is marketed at the wellhead. It doesn't just get vented into the atmosphere. All of it is marketed. The question is, where is it sold? And as the Cooper-Clark versus Oxy case made clear, sometimes it can be sold for an irrigation purpose. Sometimes it can be sold for the interstate pipeline purpose. The irrigation purpose was an issue in the Coulter case. If the case is a situation where it's bound for the interstate pipeline, that's going to be a specification that has to be met at the interstate pipeline. And if it can be met without any of the midstream services, then you've got a Sternberger situation where it's not proper to, there's no deductions that would be barred because there weren't any taken.
There hasn't been any evidence of that in any of these summary judgments though, right?
No, the reason none of that came up in the summary judgment was the good faith issue really was never an issue in the trial court. That's not something the trial court ruled upon because there was no prior case law from any place in Kansas that mentioned the good faith issue.
Well, let me ask you the question this way. When Justice Biles wrote, the duty to make gas marketable is satisfied when the operator delivers gas to the purchaser in a condition acceptable to the purchaser in a good faith transaction, OPIC satisfied its duty to market the gas when the gas was sold at the wellhead. You're saying that's incorrect because it wasn't a good faith sale.
No, I'm saying that is correct, that the marketing was in good faith. The sale under those contracts were actually at the transmission line under those contracts, an issue never litigated in OPIC 1 because it was never raised in OPIC 1.
So the amendment undermines the Supreme Court ruling because the error in the Supreme Court ruling, if I understand your argument, is it wasn't a good faith transaction. OPIC had done something with these secret contracts and that's all hidden from sight. So we can't say it's a good faith transaction. And so that rule can't stand.
No, I don't agree with that. I think the ruling in OPIC 1 does stand, and the midstream contract actually is in good faith. But under the midstream contract, the sale is not where they say it is under the paper title transfer. It is what the totality of the midstream gas contract would show, and that would show at the transmission line. So if we actually litigated that issue under those midstream contracts, we believe that the transmission line will be the location that a jury will find that gas is marketed at, and those are the specifications that need to be met under the Cooper-Clark versus Oxy test. So we don't seek to undermine OPIC 1 at all. What we seek to do is litigate now under those changed circumstances.
Counsel, I'm sorry, go on ahead.
One fundamental point, are we bound by Judge Lieben's opinion?
I do not think you're bound by Judge Lieben's opinion, but it is the most recent and also the only authoritative review of what Oxy 1 means at this point.
It's certainly the first.
It is the first. That doesn't mean it's the last. I understand that. But I must say, I thought it was very well written. And I think he makes the point that just any sale will not suffice, that the concept of marketability is tied to the market for the gas. And although he does not adopt the Chaparral test, his Chaparral test and his test is very similar. The gas contract sets the quality standard, then you have to see what's necessary to meet the quality standard. Under the OPIC 1, we believe we're entitled to litigate that issue. Let me briefly, if I could, turn to the prejudgment interest issue and the equitable estoppel issue. I don't think I have
I'm going
much
to give
time.
you, Mr. Sharp, I'm going to give you one more minute. You're actually over your time, but I'll equal that out with opposing counsel.
Thank
Take
you.
about a minute.
Okay. On the prejudgment interest issue, we believe the KSA 16201 simply applies to unpaid royalties, and KSA 551614 applies to paid royalties. Our case, of course, is about unpaid. The difference is paid royalties obviously are liquidated. They are short time span. Low interest rate makes some sense. That's not the case for KSA 16201 unpaid royalties. The equitable estoppel issue, we believe that we proved at trial all three of the elements. In particular, we showed that what was put on the accounting check stubs was deceptive to the royalty owners, and there is not an element that OPIC had to intend to deceive. It's enough that it simply was deceptive. So we would ask that the court allow us to go back and have our day in court under the changed law of OPIC 1 and try the case for the class as to whether the deductions were proper or not, and 2, affirm the trial court on the equitable estoppel issue and permit prejudgment interest to be given under KSA 16201.
I have one factual question, if I could, Judge Boozer. As I understand it, the change in the law about the conservation fee came about while this litigation was pending. Is that correct?
I believe it was very close to that. It came about in the Hawkett case, I think, in 2011. And it wasn't until a few years after that that OPIC changed and stopped taking those deductions.
Okay. Thank you.
All right. Thank you very much, Mr. Sharp. You'll have 5 minutes of rebuttal, and we're going to give Mr. Kuykendall at least 25 minutes to make his argument.
Thank you, Your Honor. I would like to start with the proposition that OPIC, the Fawcett decision, did not really change the law. Prior to that decision, there was a duty to market. Prior to that decision, there was a duty of good faith. In this case, in Fawcett, the court was concerned with the duty of the duty to market, because that was the claim that was originally filed. The plaintiff claimed that OPIC breached its implied duty to market and the marketable condition rule that the court called a corollary of that duty to market. That was the decision before the court in Fawcett, and the Supreme Court clearly ruled on that, and there's no decision, or there's no question about the decision on the duty to market. The Supreme Court stated the duty to market, to make gas marketable, is satisfied when the operator delivers the gas to the purchaser in a condition acceptable to the purchaser in a good faith transaction. And OPIC satisfied its duty to market the gas when the gas was sold at the wellhead. And that completely determines the case as originally filed.
Counsel, may I ask you a question, please?
Certainly.
Underscoring that, it seems to me Justice Biles assumed this was a good faith transaction, correct? And that was based upon the stipulation of the parties.
Yeah, he assumed it because he was told by the plaintiffs that it was a good faith transaction.
Now, if the class says this wasn't a good faith transaction, what does that do to the Supreme Court's opinion?
It doesn't do anything to the Supreme Court's opinion, because under those circumstances, the doctrine of judicial estoppel really prevents the plaintiffs from changing that position. That position was argued at the district court, before the first appeal. And in fact, it was supported by the plaintiff class in an effort to get the class certified. At that time, the plaintiff said, plaintiff class accepts the terms of the gas conditioning contracts as they are. It does not challenge the gross sales price as not being high enough. So the evidence to look at those, the good faith, those contracts would be not applicable. So they argued even at the trial court level that these sales were good faith.
It seems to me your opposing counsel was being a bit more subtle than that. That you're saying that this entire transaction now, because of some expert testimony that isn't in the record, will show that all of these contracts exhibit bad faith, and that would breach another implied duty, which is the implied duty of good faith and fair dealing, correct?
Yeah, that's right, Your Honor. Essentially, what the plaintiff wants to do is he wants to take his argument with respect to the marketable condition rule and take it out of the duty to market clause, the implied duty to market clause, and tack it onto the implied good faith clause and make it a requirement of the good faith clause that the gas be marketed on down the line. And that is not something the Supreme Court wanted to do. Had the Supreme Court wanted to say that an implied duty requires OPEC to market the gas way down the line and assume the conditioning costs during that interim, it could have done that with the duty to market. And I don't think changing the name of the implied duty changes what the Supreme Court meant. The Supreme Court...
And that's where the mandate rule comes into effect, is that right?
I assume so, Your Honor. The Supreme Court really looked at the relationship between the lessee and the royalty owner in a different light. It discusses that relationship in its opinion. It noted that if you look at what the deal was, that OPEC would produce the gas, bring it to the surface, sell it in a good faith deal, and split the costs, split whatever proceeds are received. Then that deal aligns the interests of the producer with the interests of the royalty owner. By their economic reasons, OPEC has the incentive to maximize what it gets for the gas at the wellhead, and that maximizes what the royalty owner receives. Now, if you take Mr. Sharp's approach and look at a price later on, then you suddenly don't have this alignment of interests. Suddenly, the interests of the producer and the royalty owner no longer align. Somehow there is this extra cost that the producer must accept that places it in a position that is antagonistic with the royalty owner's position. And you get into a situation where the court is completely, all the time, policing this relationship, trying to find out what the correct resolution is. The court accepted this lease deal as it was. OPEC will produce the gas, will sell the gas, and they'll split what it gets. And of course...
Does this ruling of the Supreme Court mean that anytime gas is sold, that's a fair, it's marketable?
Yes, with certain exceptions. And one of those exceptions might be the Oxy case. In the Oxy case, there you have a sale to a related entity, or you have a sale that's not on the wellhead at a later position in the market. Now, those circumstances could bring the interests of the lessee and the royalty owner into conflict. But if you simply have the deal that OPEC had, which is a common one in the oil and gas industry with respect to a lot of producers, where the producer produces the gas, sells it at the wellhead, gets as much as he can, and splits it according to the lease, then you don't have, then in those circumstances, OPIC would say, yes, that is a good faith deal. That is a good one. You can base royalty just on that and don't have to look farther.
Counsel, you just said
Yes.
good faith deal, and that gets back to my question to your opposing counsel, and that is, when we talk about the duty of good faith and fair dealing, which good faith are we discussing? Are we discussing a good faith transaction between OPIC and the middleman processing company? Or are we talking about a good faith transaction between OPIC and the landowners? What are we talking about?
I think you must be talking about a good faith transaction between OPIC and its first purchaser, because that was what the Supreme Court looked at to see if the duty to market was satisfied. If there is a good faith sale at the wellhead, then the duty to market is satisfied. And if you pay royalties based on that, then everything is fine.
And that's a little bit different from our regular contractual duty of good faith, right? Because in a normal contractual duty of good faith, we talk about that the good faith dealings between the contracting parties, right?
Correct. And I think that was the distinction that the Supreme Court made there. What Mr. Sharp wants to do is imply this duty of good faith into the lease itself, and then imply this marketable condition rule into the good faith obligation, so as to achieve the result that the Supreme Court rejected in Fawcett, and require the producer to deduct expenses made or incurred by third parties on down the line after OPIC had sold the gas. And that's an obligation that the Supreme Court said OPIC does not have to assume. That was the holding of the Fawcett case.
Counsel, I'd like to ask you about an argument that Mr. Sharp made on page 12 of his appellant's brief. And he said this, he said, the court did not decide that OPIC won as a matter of law, that OPIC won as a matter of fact, or that OPIC won at all. If it had, the court would have issued a mandate reversing and rendering judgment in favor of OPIC, or directing that judgment be entered in favor of OPIC. It did neither. Instead, it remanded the case to the district court for further proceedings. What's your response to that argument?
Well, certainly they remanded the case for further proceedings because further proceedings were absolutely necessary. There was the conservation fee that was still pending. There's a question of how do you handle the certified class when you get a judgment against it? Do you have to provide notice to the class members as to the result? This is a decision that goes first to the trial court, and what to do at that stage is really a decision of the trial court. So simply the fact that they didn't reverse and direct the court to enter judgment for us on the duty to market claim does not mean that that's not what they intended. And in fact, if you read the opinion, I don't see how you can read the statement that OPIC satisfied its duty to market the gas when the gas was sold at the wellhead as being anything other than a direction to the district court to enter judgment on the duty to market claim, because it held we didn't breach that duty. Your Honor, I would also point out that the argument about amendment is really different than the argument about whether they were entitled to judgment as on summary judgment as a matter of law. Whether the court improperly denied amendment is, of course, subject to discretion, and the plaintiffs did not make any attempt at showing an abuse of discretion for the court to deny amendment to this case, to change its position from something that it stipulated the first appeal to a different position so it could resurrect rejected claims for a second bite at the apple. Under those circumstances, there was no abuse of discretion to justify overturning the judge's decision not to permit the amendment.
Well, counsel, are you arguing that this is a matter of discretion, or are you arguing that the district court was mandated under the Supreme Court's rule to deny this? I mean, you can't have it both ways.
I think that I can argue that that the standard to apply is abuse of discretion, but the court was absolutely right because it really had no choice in how it ruled on this, because to allow this amendment would directly conflict with the holding of the Supreme Court and allow the plaintiffs to change a position that they had assumed for the first appeal to a completely different position on the second go round. So I believe that the court was absolutely right, didn't really have much choice, but the standard to apply is still abuse of discretion. I would like to turn to the second argument dealing with the rate of prejudgment interest. I don't think.
Can I ask you a factual question first?
Sure.
As I understand it, by stipulation, the parties have agreed that outside the statute of limitations, the amount is what, $45,000?
$49,000.
$49,000. And within the statute of limitations period, it's $49,000.
Yes, Your Honor.
And that's not based upon any evidence that was presented to the trial court. That was based upon stipulations made by the parties.
Yes, it was stipulated. It was a negotiated amount.
All right. So all of that, we don't have any factual problems to resolve here in that because it's based on stipulation, correct?
Yes. Yes. The dollar amounts are based on stipulations.
Now, would you agree with me that that means the amounts are liquidated?
I would say that they would be liquidated as of the date of the stipulation, and that is consistent with Court of Appeals law. But before that, the amounts really are not liquidated because they cannot be determined with mathematical exactitude. It requires assumptions, it required analysis. And in this case, trying to figure out the interest on those amounts, especially for the earlier period, is a task that the plaintiff even conceded would be both impossible and pointless. That's what they said in their reply brief. But instead of addressing the ruling that the court made that no prejudgment interest was to be awarded, the plaintiff wants to just look at whether the right rate was not applied. And that just makes no sense to me. The plaintiff needed to show at some point that the court was wrong in not applying prejudgment interest to this.
In fact, you argue it's moot.
Absolutely. The argument that they're making is moot because whether the rate was the one set by 12201 or 551516, the court didn't apply either. So it really doesn't matter. The court was right in not applying prejudgment interest because that task, given the record that the court looked at, was both impossible and pointless. Even
so are we asked to present an advisory opinion?
Absolutely. That's exactly what you're asked about. And that is candidly admitted because they're not really concerned about the interest rate in this case. They just want to establish better law for their cases on down the road. And they candidly admit that in the reply brief. I think that for that reason, the court is well to simply hold that their second argument as to which rate applies is moot. I do want to talk about the statute of limitations, which is our cross appeal. Now, we know about the statute of limitations on these claims. That statute runs from the time the wrong happened. And the court correctly held at the onset that a discovery rule doesn't apply to a contract action like this is. The plaintiffs did not argue fraudulent concealment would extend the statute of limitation. That wasn't a theory they used. And instead, the theory used was this theory of equitable estoppel as tolling the statute of limitation. And the parties agreed to the three elements required for equitable estoppel. First, you had to have a representation that induced the royalty owners to believe certain facts. Second,
Now here, there was no representation because OPIC never told them anything, correct? It was hidden. This deduction was hidden as part of the state sales or part of the state tax. Isn't that correct?
yeah, the amount of the deduction was shown every month, but it was shown in a column labeled state taxes as a component of a bigger number.
So how could a royalty owner read that in their stub and say, oh, part of this is a conservation fee?
Well, there's two ways they could have found out about it. One requires a lot of knowledge of tax law, severance tax law, and the rate of conservation fees. And you could sit down with a pen and paper and work it out. The other way is that every year they were given annual statements saying, if you have a question about this statement, call us and we'll tell you. And the testimony at trial was, if they called, they would be told. And that is not unusual because
why would they call? Why would anybody call under those facts when it's obviously concealed? Why would that question even arise?
well, they might have a question. Well, I don't know. Your Honor, they might want to know what components are included in the tax column. They might want to do their due diligence on their tax stub and ask.
But
Why are they assuming that it was?
We're looking at some sort of, if it's not concealment, I don't know what it is. It seems like to me in your argument, you're saying, well, look, everybody was doing it. Everybody else in the industry was doing it. So, you know, we shouldn't be held wrong. Well, was everybody concealing this?
Everybody was treating it essentially the same way. And it really, it really wasn't concealed because the Southwest Royalty Owners Association attorney sent a newsletter out early on saying that the state tax column of royalty checks include two things. It includes severance tax. It includes the minimal conservation fee tax.
So you're relying upon some sort of newsletter from some attorney to obviate the principles of estoppel, which the district court said. Is that right?
No, Your Honor. But I do want to say that it's not really concealed in that it was widely known. But the principles of estoppel are three things. First, there was an inducement of the royalty owners to believe certain facts. Second, the royalty owners relied and acted on those facts. How did they do that? I mean, here the question is, did we do anything to prevent them from filing suit? They didn't know. But if that's the only standard, then why isn't this just a discovery rule applied in this case? And I think that's the key point to this third part, that it would prejudice the royalty owners if OPIC were now able to deny the facts that it stated earlier. What facts did we state earlier that the royalty owners want us now to deny?
Well, clearly, when you deducted for state taxes and didn't say anything about this conservation fee, you were saying, here's what we're deducting for state taxes.
Yes.
Isn't that what you did?
Yes, it is what we did. But again, this is like any mistake on a royalty owner sheet where you are given a check stub. The check stub shows what's paid, how it was calculated, leaves some things out, or doesn't fully explain everything to your satisfaction. Under those circumstances, it should require more than, I just didn't know, I didn't discover the problem in order to toll the statute of limitation for an extra 15 years.
Counsel,
Yes.
I have another timing question, and that is, why are we talking about this now? Why didn't this come up in 2011, 2012, when the original summary judgment briefing was occurring?
Well, it's coming up now because it wasn't an issue back then. In that decision, the trial court issued an opinion that, let me find my notes, that both granted summary judgment to the plaintiff's class and certified the class. We had made an argument that there was a statute of limitation issue, and the court stated that the statute of limitation is an affirmative defense that can be dealt with by this court at a later time. It is not relevant for the court to resolve the competing motions for partial summary judgment or the questions of class certification. So the issue of the statute of limitation that we pushed then was not decided, and it was expressly not decided by the district court in the original opinion that went up to the court, the Supreme Court eventually. So it could not have been appealed because it simply wasn't decided. And now is the only time it can be raised. And unless there's any more questions, I think I will stop here.
All right. Seeing no questions, Mr. Kuykendall, thank you very much for your argument. And now we'll have Mr. Sharp for 5 minutes of rebuttal.
Thank you, Your Honor. Let me begin where opposing counsel began. He began with the argument that OPIC 1 did not change the law. It didn't change the law at all. If that's his view, where are the prior cases that say good faith sales sets the line of demarcation for whether you can deduct under the implied duty to market? There are no such cases. This is a seminal opinion. He has to argue that there's no change in the law, because if there is a change in the law, plaintiff gets an opportunity to amend and deal with that change in the law if he can. We can in this particular instance.
Counsel, did the implied duty of good faith and fair dealing exist before the first Fawcett case?
The implied duty to market has three aspects to it. The implied duty to market to get the gas to the market solely at the operator's cost, that existed, and all of the cases disallowed any deductions that were taken. In Sternberger, there were no deductions of gathering, compression, dehydration, treatment, or processing taken, so nothing.
Counsel, I don't think that you're answering my question. I'm asking whether the contractual implied duty to exercise good faith predated 2015.
Absolutely. All of the implied duties go back into the 1900s. So the implied duties have been around for a long time. What changed was the implied duty used to be based on quality of the gas. If you look at Gilmore, if you look at Schupbach, if you look at Sternberger, and what services were necessary to change the physical quality of the gas.
But isn't that discussion conflating the implied duty to exercise good faith and the implied duty to provide a marketable product?
They're totally different. The marketable product issue goes to deductions, and that issue, as was set forth in the recent case of the Oxy case, Cooper Clark versus Oxy, the court specifically said once there's a good faith sale under OPIC 1, you are done with the marketable condition rule part of the implied duty, but you are not done with the other two aspects, the best reasonable price and the issue on splitting the pie. Once you've made the pie bigger, you have to decide how to split it, and that comes in the good faith issue as well as in the mutual benefit rule. So that particular case is directly on point with this case.
I guess I read Fawcett a little bit differently. I read Fawcett to say that there are two duties, or at least two duties, implied duties that exist. One is an implied duty to provide a marketable product, and that duty was satisfied under the facts of this case. And then there's also this implied duty of good faith and fair dealing that exists in every contract, and that's not at issue in this case. Did I misread that?
No, it was not at issue. The other implied duties were not at issue in the original case because we felt we could win the original case when we asked for summary judgment based on the marketable condition rule. We could have and did, in fact, until the law changed. Now we're asking under the marketable condition rule, now that the law has changed, that we be allowed to litigate that change. And we have added the mutual benefit rule issue because that was never previously litigated and could be litigated under Cooper-Clark versus Oxy. They're totally different implied duties. The good faith and fair dealing is also a separate and distinct implied duty, which we would ask to be able to litigate. The change in the law is the only thing that would allow us to litigate the marketable condition rule issue if, in fact, defendant had won either express or implicit mandate in OPIC 1. That change in the law allows us to pursue that change in the law. I still doubt that the Kansas Supreme Court implicitly granted summary judgment to OPIC. They're pretty good about saying when somebody wins, and they didn't say anything about that in OPIC 1. With respect to a change in the law, we cited a case in our briefing, the Chicano Police Association versus Stover case, and it makes clear, quote, the proper test for the case was not in the minds of the parties at trial, it seems, just as it was misjudged by us. We feel that permitting the parties to make a further presentation under the test now made clear by the new case is the proper and just disposition for us to make. In such proceedings, the trial court may permit amendments as to claims and defenses to protect the rights of the parties and may consider further proof. We're asking this court to allow us to do exactly what was done in that case, which is amend and consider further proof as to that marketable condition rule issue. With respect to the concept of factual concession, we already addressed that. I think we did factually concede the issue of the midstream contract. We did not concede the issue of the sale under that midstream contract. That's a fact issue. We never stipulated to that issue. With respect to, and you can go back and take a look at the actual trial court transcript. I think OPIC actually put it into their brief in detail, and you'll see that we stipulated to the midstream contract, but not to what it said. And what that contract says is the subject of this dispute and the subject of most disputes. With respect to the prejudgment interest issue, that issue is not moot. It is an issue of applying the wrong statute meant we couldn't meet the proof standard. Quite frankly, no one can ever meet that kind of a standard. One, they argue that if it's an unpaid royalty, it's not going to be liquidated. That's generally true. If that's the standard, you've nullified all of the prejudgment interest issues with respect to unpaid royalties. And two, if you use this very complicated and very low interest statute, you'll spend more time calculating the interest than it's worth. So for the unpaid,
can I interrupt you there for just a second? That more specific statute was enacted much later than the general statute, was it not?
It was to address the suspended royalty issue where the payers would pay into a fund the suspended royalties and wait for the title issues to be resolved to figure out who to pay. So they actually made payment. They just didn't know who to make the payment to.
But before that, didn't the cases hold that you were entitled to the 10% in the statute for, what was that, in the Kansas Baptist Convention?
Yeah, the light cap case is one of the stronger cases on that issue, Your Honor. And it addresses the issue that it's not necessary for unpaid royalties to be liquidated. So in terms of how that could be calculated when we go back down, it could be prorated by month, which would be conservative because the larger volume of gas always comes out early in a well rather than later. So it would be conservative. You could average at the midpoint. You could calculate from the end point of the stipulated facts, which would be 2006 or 2015, or as even defense counsel admitted, you could calculate from the stipulation date itself. But it's that 10% that makes it easy to calculate and also worthwhile. Given that
All right.
there has,
Counsel, your time's running out. So why don't you sum up in 30 seconds if you can?
I will do my best, Your Honor. OPIC 1, I believe, changed the law, and we should be allowed as a fairness and justice issue to meet that change in the law if we can, and we believe we can. With respect to the amendment should not have been foreclosed by the explicit mandate or the implicit mandate. We should simply be allowed to do the change in law, go back and litigate that issue to trial. The trial that was had on the equitable estoppel issue met all of the elements. The royalty owners were deceived and they should be entitled to their money and plus interest under the 10% interest rule. We'd ask that the court allow us to go back to trial.
Thank you, Mr. Sharp, both counsel. Greatly appreciate your argument on a complicated matter and appreciate your briefing too. It was very thorough. So with that, we will stand in recess. Thank you all very much.
Thank you.
Thank you.
All right, judges, good job.
Thanks, Chelsea.
You made it through your whole docket.
Are we still live, Chelsea?
Yes, we are. Thank you for catching that.